Before I jump into the balance of my presentation and our opening statement, I wanted to go back to the timeline that I believe was one of the questions from Professor Leafley. And with respect to the reservation and what one would have expected, in other words, what could the sovereign have done? What they could have done was what they did on the 11th of June of 2018. And on the 11th of June, there's a reservation that reads as follows in Spanish. Las partes no han llegado.
The parties have not reached any agreement to submit to arbitration, nor under UNCITRAL rules or any other type of arbitration.
Is not set forth in the sovereign's letter of 24 May, and it's not set forth in the sovereign's letter of 18 May. There is a reservation in both of those letters, not with the detail as set forth on the 11th of June. And what exactly are they reserving? They can't possibly be reserving matters that they agree to in that correspondence. By way of example, in the letter of 18 May 2018, identified for purposes of this arbitration as C-132, in that letter, the Dominican Republic agrees that the UNCITRAL rules shall apply. And I'll read in Spanish on page 2 of C-132. Adicionalmente,
additionally, we take advantage of this to clarify that in this procedure, to which the UNCITRAL regulations would eventually apply, the regulations of 1976, and they continue to say, we do not believe an answer is deemed necessary to the arbitration notification.
Now, they do make a reservation of certain jurisdictional defenses, which clearly, in our mind's eye, could not include a jurisdictional objection that relates to Article 1, a lack of consent, but could include jurisdictional defenses such as indirect investors, which is a jurisdictional defense that they're positing now. The subsequent letter, 24 May 2018, which also does not have the express reservation that's set forth in the email from La Doctora Contreras of 11 June 2018, obviously can't reserve actions that are presently being taken in that correspondence. And what do they do in that correspondence? They designate Professor Cohen, thus establishing that it's not going to be a sole arbitrator, which is one of the alternatives that's set forth in paragraph 2, but rather a tribunal.
Do you have a reference also for that letter, please?
I do not, but I can provide it. And if not, I can provide the tribunal with a copy. I don't know if that correspondence is in evidence. It is correspondence exchange between the parties, and with the approval of the tribunal, I'm happy to make it approved.
We have copies of that, but that's fine. I just wondered if it also had a reference for an exhibit number. Okay.
It does not.
Thanks.
Mr. Chairman, would you like us to identify it with an exhibit number?
You can do it later.
Absolutely. Thank you, sir. We will do that. Turning now to the respondents, what we consider failed interpretation of the treaty. What is it that the respondent is arguing? And again, we touched on it a little earlier, and of course we heard in the opening presentation of our colleagues their position with respect to Article 1, Article 2, and their lack of focus on Article 3. And of course, I also note that in their mind's eye, the comma is of little consequence and of no import. But what they argue, and I'll jump to Spanish, no deja lugar,
does not leave any doubts that it's necessary to have a separate agreement in writing by the state and the investor to submit the dispute to a tribunal under UNCITRAL.
It does not provide any consent, and as a result of that, ex post agreement is required. What does that mean? What that means is that the sovereign as I articulated earlier, can always block the initiation of the arbitration. Notwithstanding the word shall, notwithstanding what was agreed in our mind clearly in paragraph 1, under their reading, even if the investor accepts the proposal, the offer to prosecute one of those three options, it's of no moment. Because one of those two options, I would assume, international arbitration, requires that the sovereign, after that action is taken, agree again, in writing. There are, of course, examples of treaties where you have ex post consent. And I'm sure the tribunal is intimately aware with the language in those laws and in those treaties. And I identify in the next several slides examples. Here's an example from the 1979 Sweden-Malaysia Treaty. And as the tribunal can tell, just on the face of the document, they're vastly different than the language that is set forth in paragraph 1 and paragraph 2 of Article 13. In the Sweden-Malaysia, it shall upon the agreement by both parties to the dispute. By both parties to the dispute. If we look at the Tanzanian Investment Act of 1997, the dispute may be submitted to arbitration as may be mutually agreed by the parties. May, permissive. Shall, mandatory. Another example from the Uzbekistan law of guarantees. The parties involved in investment disputes can, not shall, not may, can, on mutual agreement, determine the authority settling such disputes. Very, very different than the language that we see in the treaty in dispute here. And where do they ultimately conclude? What does this analysis of the sovereign here ultimately lead them in their analysis of these provisions? Well, what they say, and here is a paragraph 9 in one of their submissions, the submissions of 21 October 2019, they argue with respect to paragraph 1, jumping to Spanish, that it's meramente.
It's merely to identify potential alternative for the settlement of disputes.
And then they go on to talk about the word shall. And we've seen a number of cases that have looked at the word shall in arbitration provision and treaty provisions similar to ours, where the tribunals have time and again said shall means shall, and it's mandatory. But the Dominican Republic here continues to insist, to hope beyond hope, that shall means something less. That shall, jumping into Spanish, no se trata.
It's not a magical word.
And they say, well, don't take our word for it. Look at Black's Law Dictionary. And Black's Law Dictionary, in its laundry list of definitions for the word shall, actually says, in certain instances, shall can mean may. And they say, jumping into Spanish, definición de shall.
The definition of shall, amongst which we include the existence of an obligation as well as a possibility, should or may, or something that would happen in the future.
This morning. They say Black's Law Dictionary supports our argument. So don't look at the other cases that have defined shall just like Michael Leachin. Look at Black's. So we did. We looked at Black's. And what does Black say? Well, definition number 1 says shall has a duty to, more broadly is required to. This is the mandatory sense that drafters typically intend and that courts typically uphold. So definition number one, shall is what we say shall means, and what multiple tribunals have time and again interpreted shall to mean. Well, what else does it say? Well, it says only sense number one, that it's a duty, that it's required, that it's mandatory, is acceptable under strict standards of drafting. Well, when you're drafting a treaty, I would imagine you're dotting your I's and you're crossing your T's. You're not just doing it on a lark. No, you're strictly drafting it and making sure that words mean what they mean. And then we get to the definition that they rely upon in their footnote. May. It's not definition 1. It's not even definition 2. It's definition 3. And when, pursuant to Black's Law Dictionary, does shall mean may? When a negative word such as not or no precedes shall. Now, in this treaty, I've looked at it. Shall, in paragraph 1, is not preceded by not or no. So pursuant to Black's Law Dictionary, shall cannot mean may. Period, full stop. And to not make that clear in the footnote to support their position is disconcerting and unfortunate. So we contend that shall means shall, and that their effort to try to change the meaning, the ordinary sense of the word, based on a manipulated definition, doesn't lead them to victory. Metal Tech. What do they argue with respect to this case? Jumping into Spanish.
Preliminary, we have to remember that in international law, there is such a thing as consent to international arbitration in abstract.
Provision in this treaty, Article 1, Article 2, Article 3, makes reference to rules. It makes reference to the UNCITRAL rules, specifically. So it's different, I say. It's not in the abstract. And I understand that they have a different interpretation, and that's fair. But to say that these provisions are devoid of any reference to rules ignores the text of the treaty itself. And what's the argument here? The respondent has expressed its consent to ICSID arbitration in Article 8.1 of the BIT. Respondent submits that it consented to arbitrate only those disputes concerning lawfully implemented investments. So even in this case, looking at Article 8, which is similar, 8.1, similar to our paragraph 1, it recognizes that they consented to arbitrate lawful investment disputes. Now, do they focus on that language, the respondent, in the Metaltech case? No. They focus on Article 10 of the Law of Guarantees. This is the section that they cite in this opinion. And they claim that the claimant contends that the tribunal has jurisdiction to entertain claimant's Uzbek law claims. Now, ultimately, what happens? Article 10 of that law, not the BIT, where unequivocally established that pursuant to the BIT, lawful claims are subject to arbitration. There is consent. They say, given that that law does not make specific reference to anything, well then, there's no jurisdiction. But of course, that's not the case here, because our provision makes specific reference to UNCITRAL, unlike in Metaltech. We come back to the idea that serán has various meanings. And I come back to serán, shall, frequently, not because I'm in love with the word, but because they rely on it significantly. They rely on this idea that shall means something different than mandatory. For their position to prevail, we posit that this tribunal must accept that shall means may. And that would be, in our mind's eye, outlandish. Well, let's see what Planet Mining does with the word shall. And in the respondent's opening, they looked at the arbitration provision in Planet Mining. It was on the screen for a while. And you see the distinction between may, submit, and on the bottom in 4A, you see shall. And clearly, this is a different provision, not identical to the one in dispute here. But the tribunal here wrestles with the word shall. And Indonesia, the sovereign, contends that the wording shall, consent in writing within 45 days, contained in Article 11.4, shows that a subsequent act is required to achieve consent and that Indonesia legitimately withheld its consent. A similar argument that's being made here by the Dominican Republic. What does the tribunal ultimately conclude? The tribunal concludes, like other tribunals that we've already seen, that the use of the word shall without a stated exception leaves no doubt that Indonesia was obligated to grant its consent. So in this issue of shall and what does it mean, this case, Planet Mining, the tribunal analyzes the very issue that they're asking this tribunal to analyze. What meaning should we give to the word shall in paragraph 1 of Article 13? And Planet Mining said, hey, shall means shall. They've consented. We go back to their theory that the position of the Republic is that it just provides alternatives. That is their position with respect to paragraph 1. Options. It's a laundry list that in reality makes no sense, because the only way to rationally read Article 1 pursuant to the respondent leads you to the ridiculous conclusion that the investor is compelled to bring 3 claims simultaneously, one in international arbitration, one in local arbitration, and one in local courts. That can't be the case. Respondent's interpretation renders meaningless paragraph 1, means nothing. It's belied by its own authorities, authorities that have been relied upon for other purposes by the respondent. And we should never lose sight of the fact that the dispute resolution provisions in the treaty, Article 13, makes reference to rules, uncitrally. And why would it do that? They could always agree to particular sets of rules. So it begs the question, where can the investors seek redress if ex post consent is always required? Where do they go? Under the respondent's theory, the dispute resolution provisions, in point of fact, are in truth meaningless, because the claimant, the investor, exercising their rights under paragraph 1, needs to go, according to their theory, hat in hand to the sovereign and say, please, would you please agree to any one of these 3 so that I can try to seek vindication? And if you don't agree, well, then you know what? I don't have anywhere to go. And that simply can't be a reasonable, fair interpretation of the language of this treaty. Respondent's interpretation with respect to paragraph 2.
Sorry, Mr.
Yes,
Renzo. I have a question about these options in stress testing that argument. Is consent, maybe I can ask this another way, is your understanding of respondent's argument, where they do not concede that any consent has been given in paragraph 1, that would preclude a claim before the national courts of the Dominican Republic?
Professor Lee, I don't know. I don't know what their position would be. I'd be interested to hear from them, what redress we have if Article 1 does not provide consent. My understanding of their reading of Article 1 is it doesn't provide consent, I assume, to anything. So I don't know if we initiated a domestic arbitration if I had to go hat in hand and ask for their consent. Because as I understand it, they say Article 1 is nothing more than a laundry list that provides consent to nothing.
And I'm not referring to national arbitration, I'm actually meaning to the courts, because the courts are one of the three options listed in paragraph 1. And so would it not, by operation of law, be that that option is always available?
One would hope. But I don't know what their position is with respect to that. I don't believe that they've articulated a view on that in any of their submissions.
Sorry, but may I ask you what the claimant's views are on this? So is it possible, according to the Dominican Republic law, to bring the case before domestic courts?
Professor Cohen, I'm not a Dominican law expert. Again, as I noted in my response to Professor Leithley, I have to assume that if international arbitration is blocked under their theory of further consent, I assume there has to be a place where I can seek redress. Perhaps the only place I can go is in the Dominican Republic courts. And maybe when I file my action in the Dominican court, which of course would make no sense for a Jamaican investor, in my mind's eye, to feel protected in bringing an action against a sovereign in a domestic court. I don't know what the sovereign's reaction is going to be if I bring that claim. Perhaps they'll move to compel national arbitration. I don't know. All I know is that it hasn't been stressed or addressed with any degree of specificity in any of the respondents' positions. So I don't know where that would leave us. But I have to assume that we could endeavor to bring a claim in a domestic court.
Yes, I just don't know, and I'm assuming maybe if I understand respondents' argument, that there would be sovereign immunity, perhaps.
That's exactly right.
That then it might not automatically be. Therefore, you could put domestic litigation in the same box as national and international arbitration as something that would require consent.
Professor, I agree. And my understanding of the argument, quite honestly, the way they look at paragraph 1 is that it means nothing. It's just a laundry list of options, and that consent is required because paragraph 1 provides consent to nothing under my understanding of their theory. And I don't believe under their theory it's limited exclusively to the issue of international arbitration. Turning now to paragraph 2, and jumping into Spanish, and we go back to the second layer of consent. Sin ese acuerdo.
Without that later consent, as the dispute arises, there is no consent by the state to national arbitration in accordance with the terms of Article 13 of the treaty.
Argument. We want to look at 4 subsets of issues. And the first is the Vienna Convention, which of course was addressed by our colleagues' counsel for the respondent. And we all know, of course, the Vienna Convention, and we're all familiar with Article 31, General Rule of Interpretation. A treaty shall be interpreted in good faith. Is it good faith to say shall means may? In accordance with the ordinary meaning to be given to the terms of the treaty. Is the ordinary meaning of shall may in the context and the light of its object and purpose? One of the objects and purposes of this act, of this treaty, of Article 13 in particular, is to provide a viable forum for a foreign investor to vindicate or attempt to vindicate their rights. If the only vehicle, place where vindication could happen is in a domestic court, maybe if there is no sovereign immunity defense, and arbitration, international arbitration in particular, requires an additional layer of consent from the sovereign, is that reading of Article 13, paragraph 1, paragraph 2, and paragraph 3, is it reasonable? Is that consistent with the object and purpose of Article 13? We posit no. And is it reasonable? Is it good faith to say that the words o, or, in paragraph 1 should really mean and or e? Is it really good faith to say that we don't really need to look at the comma? The comma is inconsequential, I believe is the language that they use. The comma is inconsequential. And Article 3, I apologize, paragraph 3, even though it speaks to the issue of who accepts the offer, the investor? Well, given that that's really a state-to-state issue, and even though it's in the same Article 13, it really adds nothing to the tribunal's effort to try to interpret the balance of the provisions. So again, we go back to shall. We contend that it is not the ordinary meaning to say that shall means may. It's not the ordinary meaning to ignore the first part of paragraph 2 that begins where the dispute is referred to international arbitration. And it is not ordinary meaning using the words posited by the respondent with respect to the comma that it's totally inconsequential. Mind you, this is not the English text. This is the Spanish language text. And words have meaning. Commas have meaning. They choose to ignore them. In their context, respondent's interpretation ignores the concept of paragraph 1 and renders it meaningless. That's what they argue. Respondent's interpretation positions in conflict paragraph 1 and paragraph 2. And they say paragraph 2 trumps paragraph 1. They ignore, as I noted earlier, the impact of paragraph 3. And in our mind, their interpretation destroys Article 13's effect utile with respect to international arbitration, because it gives the key to that dispute resolution forum exclusively to the sovereign. And what was the object and purpose of the treaty? To promote greater economic cooperation, recognize the needs to stimulate and protect investments, to strengthen economic ties. And when this treaty was being considered by the Dominican legislature, well, what did the Senate say? Well, they said, listen, the treaty is necessary because we need a legal judicial framework to promote and protect investments. And mind you, this is reciprocal. The Dominican Republic wanted to protect its investors that were going to Jamaica, going to CARICOM, no differently than CARICOM wanted to protect its investors that were going to the Dominican Republic. I'm confident. Yes, sir.
Mr. Lorenzo, in your view, the word judicial includes arbitration.
It does, yes.
Judicial.
Yes.
Thanks.
What was that framework? The framework is set forth in Article 13. And the framework contemplates court, domestic arbitration, international arbitration. And going back to the veto issue, it's just unreasonable, not consistent with treaty interpretation, to read Article 13 and find that a second layer of consent is required. We contend, Mr. Chairman, members of the tribunal, that the reading that is mandated by the respondent is not a good faith reading. It's not a fair reading. And it requires that the provision be modified extensively, and it requires that other provisions in Article 13 be ignored. The preparatory works. And of course, under Article 32, they can be considered. And we've asked for these. Obviously, Mr. Lee Chin can't knock on the door of the Dominican Republic and say, I would like all the preparatory works, please, of the CARICOM Treaty. So we needed to ask the sovereign. And one would have to assume that the sovereign, with respect to treaties, international treaties, maintains somewhere the preparatory works associated with those treaties. So that if a dispute sometime down the road would manifest itself, they would have the institutional documentation and background to help explain them, if necessary. We asked for that. And the response was, well, they were lost in a fire. Maybe. Because there was no evidence. They just knew that there was a fire in a place where the documents could have been held. So then on the 18th of October, we understand that they find documents at the Banco Central. And what's interesting, notwithstanding their representations that they made a diligent search, they actually reach out to El Banco Central on the 11th of September. The responsive documents were due on the 3rd of September. So their diligent search that led them to a fire of an area where maybe the documents were held, apparently there was an epiphany after the due date of the production that caused them to reach out to El Banco Central. Well, and luckily, I guess, the Banco Central found something. And they put a lot of weight on this preparatory work. Even though they say that the treaty is clear on its face, you don't have to look at anything. I don't need a witness. I don't need an expert. I don't need anybody. Just read it. They put a lot of weight now on this preparatory work. This is, the Holy Grail. And we should rely upon it, and we should really look at it, and we should consider it biblical truth. Even though the iterations of this clause, there were 19 rounds of negotiations. 19. They found preparatory works for 7 rounds. The balance of the rounds, which could touch on this provision, we'll never know, were burned, lost, or somehow misplaced. But we'll look at them nonetheless. The handful of documents that they managed to discover established that when the first draft of the treaty was circulated, the Dominican Republic was not even contemplating investor disputes. It was state to state, as you can see in slide 110. And over time, very quickly in fact, CARICOM proposed investor-state dispute resolution provisions. And it's Article 11 that you see on the screen on page 111. And we believe this provision contains, in paragraph 1, a binding offer of consent. And then it goes on in paragraph 2 to refer to the options that were available in this preliminary draft. And this was reviewed also by my colleague, La Doctora Frutos Peterson. And of course, over time, what happened with this provision? Well, it not only contemplated UNCITRAL, but it also contemplated ICSID. But as the final draft of the treaty ultimately bore itself out, ICSID was dropped, and the word either was eliminated. And we were left with the provision that we have today, which is strikingly similar, once ICSID is dropped, to the provision that was set forth in Article 11 of the preparatory works. Now again, the respondent's interpretation ignores the deliberate choice in Article 1 of international arbitration, and that the dispute shall be resolved there. It ignores, of course, where the dispute is referred to arbitration. That language remained. And of course, it ignores the party's deliberate choice to leave the UNCITRAL rules as a default option, as set forth in draft Article 11 and ultimately included in Article 13. Now, our interpretation of Article 2, we believe, is the most appropriate. But given that there's a debate as to how that provision should be interpreted, we sought out the individuals that led that negotiation. Ambassador Hilton and the Dominican ambassador, Ambassador Zade. And we met with them independently, and we ultimately obtained the declaration from both. One which was stricken at the request, incredibly, of the Dominican Republic. The Dominican Republic doesn't want this tribunal to know or to hear what their own ambassador believes to be true. Mind-blowing. But it doesn't matter. We have the testimony of Mr. Hilton, of Ambassador Hilton. He will be here. His credibility can be tested on cross-examination. They may want to discount it. They may want to say that it's the recollection of a tired old man. But what I can tell you about the ambassador is that he recalls. And what I can tell you about his testimony is that it's unrebutted. It is unrebutted. They had the opportunity in a litany of submissions to find one person in the Dominican Republic, one human being that participated in that negotiation, who lived it, who understood how these treaties were managed over time, to say that interpretation of Ambassador Hilton is wrong. The interpretation of Ambassador Zaide is wrong. The claimant's position with respect to consent is wrong. There isn't a single representative, witness here that challenges the statements that are made by this ambassador, that challenges the statements that were made by Ambassador Zaide. Regrettably, he's not here, and we all know the reasons why. But again, they don't want to hear from him. They don't want this tribunal to consider him. But irrespective of that, the testimony that is here is unrebutted, because there isn't anyone from the Dominican Republic who has been willing to come to this tribunal and say that the argument that's being posited by its lawyers is accurate. In addition to the other points that we've already identified, the respondent's interpretation of paragraph 2 is at odds with relevant arbitration jurisprudence.
Sorry,
Yes,
Mr.
sir.
Lorenzo. I think you're soon going to move off the text, and I'm kind of held up on the text still. And I have one more question,
Sure.
if I may. You've already answered my question about the y la parte language.
Yes, sir.
I'm trying to now explore the redundancies that could exist either way. And one potential redundancy that I'm worried about, or that I'm thinking about, is the podrán acordar, which for me has two challenges for claimant's position. One is the plural, and the other is the verb. And the plural invites that both be involved in the verb, to agree. And so I wondered what, I've seen this in your papers, but I wondered if you could just address that briefly.
Sure. And could I approach that screen just so I can? Great.
Please.
And I think you're referencing, Professor Leafley, the podrán acordar, correct?
Exactly. So that's line 2 of paragraph 2.
Line 2 of paragraph 2. And you're saying, well, this is more than one,
Yep.
correct? And well, how do I reconcile that?
Well,
What do they have to agree to?
That's right. It's giving, arguably, both parties a role to agree.
Correct. May agree to un árbitro internacional, one arbitrator, or a tribunal. We contend that, factually, the parties agreed that this arbitration would proceed por un tribunal arbitral, through the correspondence, etc. If the parties are unable to agree to this, there's a comma here. Okay? There's a comma here. What flows? Well, then, there's a special agreement. They could theoretically agree to a special agreement. And if the parties do not agree to a special agreement, well, then the arbitration proceeds as established under the rules of UNCITRAL, which include a rule that specifically addresses how arbitrators are selected.
And doesn't the podrán acordar also apply to the UNCITRAL rules?
No.
Why not?
Number one, because of the comma.
But podrán acordar refers, I would say, at the first level to either a sole arbitrator.
Correct.
I was referring to it as an institutional. Perhaps that's a mistaken interpretation. I think a better reading is a sole arbitrator as against a tribunal, an ad hoc tribunal. But isn't that what they have to agree on? And then you.
On what? I apologize. I missed it, Professor Lee.
So the podrán acordar is they may agree to either one or three. And your case, I know, is, as a matter of fact, 3 was agreed to. That's your position.
That's one of my positions, yes.
Right.
My other position is, even if the parties did not agree to 1 or 3, then the parties could agree to a special arrangement. If the parties do not agree to a special arrangement, which in this instance they did not, then the arbitration shall proceed under the the UNCITRAL rules, which are the default rules. And those default rules provide for, if the parties cannot agree on 1 or 3, whether or not it's 1 or 3. Because the UNCITRAL rules, I believe it's Article 25, Article 5, the manner in which the number of arbitrators is determined.
And what would that default be? I should know the answer to this under the UNCITRAL rules, but where would that? Will we default to 1 or 3?
I think it's 3.
It's 3 arbitrators. It says, it's Article 5.
Yeah, no, they both.
Article 5, if the parties have not previously agreed on the number of arbitrators, and if within 15 days after receipt of the respondent of the notice of arbitration, the parties have not agreed that there shall be only 1 arbitrator, 3 arbitrators shall be appointed. Sorry.
Thank you very much.
Thank you, sir. Yes, sir. I'm sorry.
Yeah, Mr. Lorenzo, just to understand you well, so your first step is the investor and the party concerned may agree to 1 arbitrator or tribunal. And consequently, if they may agree, they can also disagree.
They could disagree.
Yes. So then, if there is disagreement, then the rest of paragraph 2 comes into play. That's it.
Yeah. If there is a disagreement,
So, but if there is a disagreement, then there is a possibility of a further agreement. Is
Well-
that your point?
no, sir. Yes and no. I'll try to. I'll try to clarify. I do what I can. If there is a disagreement,
You can say also maybe. Yes,
yes,
and
no, or maybe. I'll put them all on the table.
Respondent will be selectively extracting part of that answer.
No, there'll be an ellipses there. If they're unable to agree on 1 or 3, which again, factually, I don't believe to be the case here, then the parties can attempt to agree on a special agreement to resolve the issue of appointment of the tribunal. Special agreement, tribunal to be appointed by a special agreement. Okay? If there is no special agreement, because the respondent doesn't want to agree on a methodology to appoint the tribunal, then the default are the UNCITRAL rules. And the UNCITRAL rules, pursuant to the rules themselves, have a rule that addresses the manner in which the tribunal is to be conformed. 1, 3, etc. I apologize for turning my back, Professor Cohen. Okay? Did I answer the question? You may not. You're not convinced. I hear you.
Because your point is they can agree about having 1 arbitrator or a tribunal.
Correct.
But if they disagree, then there will be a tribunal.
No, sir. No.
Because the special agreement would be about what? You said to constitute the
How to
special...
appoint them.
how to appoint
And
what?
that's the language that it says. If you look at the language,
The
the language says, may agree to refer the dispute to an international arbitrator, 1, or ad hoc arbitration tribunal,
Yes.
3, 5, 15, whatever the case may be, to be appointed by special agreement. So if the parties are unable to agree on 1 or 3 and are unable to agree on a special agreement to determine how to appoint 1 or 3, then it defaults to the uncitral rules. And the uncitral rules, in the rules themselves, determine how to appoint the tribunal. So the nuts and bolts of the arbitration, in other words, how do I appoint the tribunal, is either mutually agreed by the parties. And in the absence of mutual agreement, it's not that they walk away from their consent and they get a free pass. No, then it defaults to the uncitral rules. Thank you, sir. Going back to the relevant arbitral jurisprudence, and we come back to Garanti. And what we see here on the screen is a provision which is very similar to ours. Article 1 of the Turkmenistan BIT shall be submitted to international arbitration. Very similar to the language in our treaty. Shall be submitted to international arbitration. One of options. The tribunal there took it upon itself. We look first at whether Turkmenistan has consented to participate in international arbitration at all. That's the exact question that's being posited by the sovereign here. Through Article Paragraph 1, have they consented? What was the tribunal's decision? Article 8.1, language similar to ours, shall. Article 8.1 established unequivocally Turkmenistan's consent. Turkmenistan has consented to arbitrate disputes with UK investors, period. So they have found the consent. And then they also look at 8.2, because 8.2 has language similar to paragraph 2 in our treaty. And they title this section, what kind of arbitration? What are the nuts and bolts of the arbitration? Not the consent issue. And what does the tribunal there opine? Hold. The tribunal holds, we find in Article 2, only a menu of options concerning the arbitration process and a default selection, as we contend exists in our paragraph 2 of our treaty. Consent, as explained in the preceding section, 8.1, our paragraph 1, is granted in Article 8.1 of the UK Turkmenistan BIT. And then it looks at where the dispute is referred to international arbitration. The same phrase in our treaty, indicating that 8.2 only comes into play after the determination has been made under the provisions of 8.1 to refer the dispute to arbitration. This tribunal analyzed similar provisions, found consent in the language of Article 1, and found that what was 8.2, our paragraph 2, focused on? It was what kind of arbitration? A menu of options concerning the arbitration process, flexibility to give the parties the opportunity to attempt to agree on a laundry list of things, a few things, and if not, then it defaults to uncitral. Under no set of circumstances was it envisioned that in that laundry list menu of options, they could hold the consent to arbitration in paragraph 1 hostage. And what do they say with respect to this decision? Well, clearly the respondents don't agree with it. What they say is it's wrong and it's isolated. It's there, but they have the opportunity, of course, to disagree with it. And what they say is, ignore the majority opinion. Focus on the dissent. And the dissent was authored by a well-regarded, of course, arbitrator appointed by Curtis. But even if you look at the dissent even says that without mutual agreement between the claimant and the respondent in the nuts and bolts of the arbitration set forth in Article 8.2, only unsatral ad hoc arbitration is available. Why? Because that's what it says. That's the default. No different than the provision in our case. Which leads me to the interpretation of Article 2 that is being posited by the respondent. And what they are asking this tribunal to do is ignore the unequivocal consent in paragraph 1. Ignore the word shall. Ignore all in paragraph 1. Ignore paragraph 3. Ignore the language in paragraph 3. And with respect to paragraph 2, modify it. And everything that's set forth in paragraph 2 requires their unequivocal subsequent consent. And if they don't provide it, then there is no consent. If they don't agree, there is no international arbitration. The keys to that kingdom lie exclusively in the Dominican Republic. Period. Full stop. And we believe that that interpretation is wrong, and we believe that that interpretation is inconsistent with a good faith reading of Article 13, inconsistent with the Vienna Convention. Consent via the MFN clause. This is an issue that I know was touched on by my colleague, La Doctora Alvarez. Obviously, we believe that there is unequivocal consent through paragraph 1. I'll touch briefly on this, but assume it's going to be an issue that's hotly reviewed by our expert and will be hotly challenged in cross-examination at the appropriate moment. There is, of course, an MFN clause in this treaty. We understand that clause to be broad, and pursuant to our expert, we believe that as an alternative argument, that MFN clause can be utilized to support, number one, our theory, and number two, consent if necessary. Which leads us to the jurisdictional objection, and leads us to what is being argued by the respondent. We contend that the jurisdictional objection is not supported by a fair, good faith reading of the text of the treaty. It's not supported by the preparatory works. It's not supported by investment arbitration decisions, which we've reviewed and the tribunal has now seen again. Is not supported by the authorities relied upon by the state. It's not. It's not supported by the treaty's lead negotiator. It's not supported by the Dominican lead negotiator. It's not supported by reference to other BITs, not supported by any expert, not supported by any fact witness. The jurisdictional defense was an afterthought. It's not what the Dominican Republic, we contend, believed to be the right action to take. We believe the Dominican Republic knew that they consented to arbitration. They acted as though UNCITRAL was unequivocally the rules that were going to bind the arbitral process. The opportunity presented itself to raise a consent jurisdictional defense. They leaped at that opportunity. And the goal is clear. Number one, to delay. And number two, to avoid the economic consequence of what is a clear expropriation, under the hope that this arbitration will die here so that they can compel Mr. Lee Chin to take action somewhere. Where? Time will tell. That can't be the outcome of this case. We believe that they've consented to jurisdiction. We believe that the treaty covers indirect investment. And we believe that this case should promptly and expeditiously move to the merits. Mr. Chairman, members of the tribunal, colleagues, and of course, representatives from the Dominican Republic, I thank you for your time, and I'm available to the extent possible to address any questions the tribunal may have. Thank you, sir.
Thank you. Thank you. Before time, ¿cuántos minutos?
Claimant has used 1 hour and 40 minutes.
Thank you. So you have a bonus of 20 minutes for the future. You may use, not shall. Okay. Any question?
I just have one question on your relief, sword.
Oh, yes.
You say both in your two submissions on jurisdiction, the declaration summarily dismissing the state's jurisdictional challenge. Should we read anything into summarily?
Fast?
Thank you.
Well, vamos a hacer un pequeño break.
Let's take a small 10-minute break to call the witness and begin his interrogation. Thank you.
Everybody's ready? Yeah? No objection? Good afternoon, Mr. George Anthony Hilton. I assume that you are. When you speak, please put the.
Correct.
So, can you confirm that you are Ambassador George Anthony Hilton?
I am.
Please, I assume you know, we are here to decide about the jurisdiction of the arbitral tribunal, which means whether we can keep this case without an adjudicated. And in order to know that, maybe your intervention can elucidate some issues we have at stake. For that, it is very important for the arbitral tribunal to know if you have prepared personally your statement.
I have.
And you confirm all the items that are there.
I confirm.
So, and you know that you must say the truth for us.
I will when I do.
Okay, thank you very much. So the organization is, according to the program, first the party who presented the witness can have the possibility to present the witness, and then we will go to the cross-examination. Please, Mr. Lorenzo.
Be Mark Cheskin. That actually happens a lot. There we go. Trade.
He has more hair than I do, so that's okay.
Please, Mr. Cheskin.
Yeah, good afternoon, Ambassador.
Good afternoon.
In front of you, you have your witness statements, as you just said, and for the record, they're proofs C-138 and proof C-139.
Correct.
And do you have any changes that you would like to make to those witness statements?
Not at all.
Okay. For the benefit of the really excellent court reporters and the translators, as you're answering questions, if you could maybe make sure that the question is over and you speak, clearly, slowly, I know it'll be much, much appreciated. And so with that, I tender the witness.
Okay.
Buenas tardes, miembro del tribunal.
Good afternoon, members of the tribunal. I will perform the cross-examination. I will ask in English to facilitate the process.
One of the lawyers who represents the Dominican Republic in this case, and I'll ask you a few questions relating to your witness declarations.
Sure.
Since we have limited time, I would appreciate if you can answer specifically the questions I will pose to you. If you need to provide further clarifications, you'll have an opportunity to do so during redirect examination. You have a cross-examination binder in front of you, which contains your witness declarations as well in tabs 1 and 2, and a series of documents about which I might ask you a few questions. Those documents are separated by number tabs, which I may refer to during your cross-examination. Okay. Okay, let me ask you first, who asked you to give witness testimony in this case?
I was called, first was called, got a call from Mr. Leachin asking if I recall being a part of the negotiation in the agreement between CARICOM and the Dominican Republic. And I answered yes, and he asked that if would I be willing to speak with his attorneys, and I said yes, they could be in touch with me. They followed up subsequently, and I responded to their queries.
Okay. Have you drafted your witness statements yourself?
I did.
Did you receive help from claimant's lawyers in the preparation of your witness statements?
They would have made minor format changes, but the substance of it is my testimony.
Perfect. Prior to the preparation of your witness statements, had you ever analyzed the language of Article 13 of Annex 3 of the Free Trade Agreement between the Dominican Republic and CARICOM?
I would have at the time that the agreement was negotiated, yes.
Okay. Do you have any idea of how many provisions does the Free Trade Agreement with the Dominican Republic and its annexes approximately have?
Quite a number. I don't recall figures. No,
okay.
Quite a number.
What documents, notes did you review both in preparation of your witness statements and of this oral testimony?
I reviewed the agreement itself. I reviewed my witness statements, and I was shown documents that were forwarded in discovery of the documents by your side to my lawyers. Perfect. Or to the lawyers in this case.
And before your preparation of especially your first witness statement, have you reviewed any notes or documents?
I did review the agreement.
Only the agreement?
Yes, only the agreement.
Did you have any other contemporaneous documents that you review to prepare your first witness statement?
None other than the agreement itself.
Okay.
The provisions.
Let me ask you first a few questions about your background. You're currently a member of the Jamaican Parliament, right?
I am.
You have been one since 1993, haven't you?
I've won and lost, and won again.
Okay. Do you have political aspirations within your party, the People's National Party?
I have, and I've had, and do have, yes.
Okay. In fact, you run to become president of your party in 2017, right?
No, I became chairman. The president is.
Okay. You occupied several ministerial and governmental positions for more than 15 years in Jamaica, didn't you?
Correct.
Okay. When did you become Minister of Foreign Trade of Jamaica?
Foreign trade was about 2000, but I was minister in the foreign ministry before then.
Okay, yeah, the year 2000 you say then, right?
I became minister, but I was a minister of state in the ministry before then.
Before, okay. For how long did you hold the position of Minister of Foreign Trade?
In the first instance, for a year and a half, perhaps.
Okay, and which were your positions before that?
Minister of State in the Ministry of Foreign Affairs, and Parliamentary Secretary in the Ministry of Foreign Affairs.
Okay. You held for almost 5 years the position of Ministry of Industry between 2012 and 2016, right?
Correct.
Roughly.
Roughly, yeah.
You're also currently a partner at Samuda & Johnson, an important law firm in Jamaica, right?
I am.
Okay. Do you know Mr. Lichin personally?
I would say not. I know.
We are not getting the translation into Spanish.
Okay. Okay. Do you know Mr. Lichin personally?
I would say no. I know of Mr. Lichin as an investor in Jamaica. I have no personal dealings with him. I've never associated with him other than in the public space, maybe at public meetings or in other public gathering. Never had a personal.
Okay, but I don't mean. Have you? Oh, sorry. But you have met him probably then while you were holding different governmental ministerial positions, right?
I'm sure I have, not for in a personal meeting, but in public spaces.
In public spaces?
Yes.
But no private...
no private
meetings?
No.
Okay. In those public spaces or different, meetings that or events that you had while you were holding governmental and ministerial positions, how many times you would say you have met Mr. Lichin roughly over the years?
I'll be guessing, but I would imagine maybe 4 or 5 times, but I'll be guessing.
And have you interacted with representatives or executives of Mr. Lichin companies while you were holding ministerial governmental positions?
Repeat the question.
Have you interacted or met with representatives or executives of Mr. Lichin's companies while holding ministerial or governmental positions?
Did you say company or companies?
Companies.
Companies.
Yeah. He has many companies.
I'm not sure I know all of his companies.
Okay, but the ones at least you know.
But well, more particularly, there's a bank that I bank with at one of the banks I bank at, and I've met the managers and executive of the bank. I don't know of any other public
companies.
I was told recently that he had investment in a company that I have had dealings with, Kingston Wharf Limited. I've told that he has an investment in it. I'm sure it's not an active player. It's a passive investment, as far as I know. Wasn't aware until I was told that he had investment in it, or through his company had an investment in it.
Okay, when did you get to know that?
When I saw your documents that was produced, I saw that the focus of it was on an article that I wrote as in my capacity fairly recently. I was not minister at the time. I was in the opposition, as I am now. And I wrote an article that included reference. It wasn't about the company. It referenced the company as one of the entities that have responded to an initiative for which I was responsible in government.
Okay.
And I made reference to them, and I was subsequently told that he had an investment in it.
Now that you're referring to that, and you're referring to that investment, can you explain to us what is the Global Logistics Hub Initiative?
Global Logistics Hub Initiative is an idea that, as minister, I promulgated, which is to have Jamaica play a central role in the Americas and in the Caribbean in particular, around logistics and logistics operations.
Okay. This project was one of your flagship projects as Minister of Industry, right?
It was one of the main project for which I was responsible.
Right?
Yes.
Perfect.
Correct.
And well, you already told me. So you were not aware that Kingston Wharves Limited, one of the major contributors to your project or one of your flagship projects, was one of Mr. Lichin's companies, right?
I didn't know of the investment at the time.
You didn't know?
No.
Okay. Have you interacted with Mr. Lichin or any of the representatives of this company while you were responsible for this project?
Not about the project. The representative of the company, namely the CEO at the time and the chairman at the time, I knew as representing the company, and we interacted on the basis of their expressed interest in the project. But outside of that, I had no discussion either with Mr. Lichin or any of them about Mr. Lichin's interest in the project, in the company.
And as you told us before, you still hold the position of Shadow Minister of Industry.
Correct.
Don't you currently?
Correct.
So in a way, you're still related to this project.
Correct.
Okay. Have you ever had any professional or commercial relationship with Mr. Lichin or any of his companies besides what we were just discussing?
Not with Mr. Lichin, and if I had interaction with any of his other companies, unknown to me. But not with him.
Okay. one of the partners of your law firm was a non-executive director of Radio Jamaica Limited, one of the companies of Mr. Lichin, right?
I didn't know that that was a company of Mr. Lichin.
You were not aware of that?
No.
But you're aware of that now, right?
Yes. I'm assuming what you say is correct.
Yeah. And we can go to the document, but you do know that one of the partners of your law firm was a non-executive director of Radio Jamaica now, right?
He wasn't at the time that I was at the firm, prior to my coming to the firm.
Okay. Let me ask you a few questions about the negotiation of the free trade agreement.
Sure.
Before the negotiation of this free trade agreement between the Dominican Republic and CARICOM, had you participated in the negotiation of any other trade or investment agreement?
Several others.
Which ones?
WTO, Free Trade Area of the Americas, bilateral agreements, Venezuela, CARICOM Venezuela, CARICOM Colombia,
okay,
and a few more.
Okay, you just mentioned those two. Those two were CARICOM free trade agreements, right? The ones with Venezuela and Colombia.
No, what they call partial scope agreement.
Okay, but that was not an agreement that Jamaica signed. It was a CARICOM agreement, right? CARICOM with Venezuela and CARICOM with Colombia.
Jamaica would have signed as well.
Yeah, but it was CARICOM the party in those agreements, right?
Collectively, yes.
Collectively, perfect. Do you know if those trade agreements contain an investment chapter or annex?
They usually do. I haven't reviewed them recently, but they usually do.
Do you know if those trade agreements gave the investors direct access to international arbitration against the host state?
I cannot now recall.
Okay. You say you were the leader of the negotiating team of Jamaica during the negotiation of the free trade agreement with the Dominican Republic, between the Dominican Republic and CARICOM, right?
I was.
Okay. Were you the leader during the whole period of negotiations, even during the final stage and execution of the agreement in mid-1998?
I think I was, yes. I recall that I was, yes.
So during the whole period?
Yes.
In which of the negotiating rounds did you participate?
Several. I can't recall if I was absent from any, but for the benefit of the tribunal, let me explain that there are several rounds of negotiation at different levels of the negotiation. There are negotiation at technical, ambassadorial, and ministerial. I would not have participated at the working group or technical levels, but I would have participated at the ministerial levels.
Okay, let's go to tab 6 of your binder.
6, you said? Did
Yep.
you say 6?
Number 6. Here, this is, there is a translation first, and then you'll see the document in Spanish. We just translated the relevant paragraph. Here, this is the meeting of the first round of negotiations, which took place in Kingston, Jamaica in July 1997, right?
It appears that way, correct.
Okay. And you participated in these meetings, right? Your name is in there.
As indicated, yes.
Yeah. At that point in time, there was still no discussion on the inclusion of an investment annex in the free trade agreement, right?
I don't recall. I can say that there were preparatory meetings previously. I can't recall if there were specific discussion on investment at those early stages.
Okay, but you said you participated in meetings after the first round or not?
Correct.
In official meetings?
Correct.
Okay.
At ministerial level.
So you said you participated in all the meetings up to the stage where the treaty was signed in July 1998?
No, my exact words were, I don't recall that I missed any. If I did, it would not be more than 1 or 2, but I was there substantially all the time.
Okay, you're aware that in these meetings there are a list of delegates for each of the countries that participate in these meetings, right?
Sure, they usually do.
Okay,
Yes.
and why then your name does not appear in the list of delegates of any of the other meetings besides this first meeting?
I don't know that it hasn't. It does not appear. I don't know. It should. I don't know that it does, particularly at ministerial level meeting, because I led those negotiations for and on behalf of CARICOM.
Okay, we'll go through that later. So you say there is a distinction between the ministerial level meeting and one sort of other meeting. So, for example,
Absolutely.
yeah. And what are the other meetings that are not ministerial level meetings?
Working group meetings,
Okay.
expert level meetings, ambassadorial meetings, ministerial meetings, heads of conference, heads of government meetings.
Okay. How would you qualify this one where you did participate, which was the first round of negotiations?
Oh,
Your
that
name appears.
qualified?
Yeah, I mean, what would be a ministerial level meeting, heads of agreement, of heads of government meeting, a working group meeting?
No, that would be a ministerial level meeting.
This is a ministerial level meeting.
Yes, that's my recollection, yes.
Okay. And this is called the first round of negotiations.
It appears to be that way, yes, I
Yes.
recall in Kingston, yes.
Okay, in Kingston, perfect. Well, let's go to your second witness declaration. In your second witness declaration at paragraph 10, it's in tab 2, you need to refer to
Paragraph
it. 10.
slope, yeah, okay, yeah.
You say that the free trade agreement between the Dominican Republic and CARICOM, the negotiations of that free trade agreement were unique among several trade agreements in which you participated, and that the treaty remains indelibly imprinted on your mind.
Correct.
Correct? Okay.
Correct.
Then if this trade agreement was so unique and these negotiations were so unique, why did you not include the negotiation of this free trade agreement in the profile that you submitted before your political party in 2017, but you did include the free trade agreements with Colombia, Venezuela, and Cuba? You can go to tab 7 if you want to check that.
Yeah.
Page 4. We highlighted the portion for you. Page 4. You see that you included as in that time frame the negotiations of the free trade agreements, the CARICOM preferential trade agreements with Venezuela, Colombia, and Cuba. There is no mention of the free trade agreement with the Dominican Republic.
It's of no real significance. The fact is that I still haven't mentioned a lot more that I've done. I previously didn't mention Cuba as one that I participated in.
Yep.
And quite frankly, it has no real significance in what was an internal election and discussion. This was not for the general public consumption. This was for an internal party discussion. So, and it shouldn't be assumed that these are the only ones that I participated in. I participated in many more.
Okay, so you say this profile that you submitted to a political party to become, as you said, chairman, I think, of your political party was not significant. So you didn't, I mean, it's a 6-page, very detailed profile, basically including your positions and the highlights year by year.
That's not what I testified to. That's not what I testified to. What I said, you asked why it was not included.
Yes.
I said that was of no real significance. I was just simply giving examples of the trade negotiations I was involved in, and there's a lot more that is not included, as you'd have seen from my other CVs.
Yes, but why then you consider that the Venezuela, Colombia, and Cuba free trade agreements with CARICOM were significant to include?
Those were just examples. I didn't include Costa Rica. I participated in the Costa Rican agreement. That was not included.
But
so
when
there was no real significance of not including it.
Okay.
I was making a statement about CARICOM DR. I was just giving examples of the types of agreement that I participated in.
But if you said that this was such an important agreement in your career and remains indelibly imprinted on your mind, wouldn't you think that would have been logical to include this in such a detailed CV?
No. I didn't say it was such an important agreement in my career. It was a significant agreement because I remembered it for other reasons. I remember the agreement for other reasons. I wouldn't categorize it as one of the most important agreements, but I remembered it for other reasons, and I can be more particular about the reasons.
You're aware, by the way, now that you mentioned that CARICOM during that time frame negotiated 4 trade agreements with Venezuela, Colombia, Cuba, and the Dominican Republic, right, during the time frame of your position as parliamentary secretary.
Well, that time frame wouldn't be limited just to parliamentary secretary.
Okay.
The time frame went into Minister of State and ultimately to Minister.
And of the 4 trade agreements, the only one missing is the one with the Dominican Republic. That you participated in that period, right?
No, I'm saying I was participating in several other trade negotiations, including ACP negotiation, Africa, Caribbean, Pacific negotiation.
Which are the other reasons why you say that this was such a unique agreement then?
Well, because there, at the start of the negotiation, it became very clear that we had some very difficult issues and some problematic areas for discussion. Namely, it became clear to us that there was a law 173 that required agency arrangements between entrepreneurs or business persons wanting to do business in the DR and to access the DR market. It became very clear to us that that particular provision would pose significant challenges. Our private sector became very concerned about it, and they were, quite frankly, very strong on the fact that we had to either eliminate it or to somehow attenuate that agreement. So it became a very problematic provision.
Okay. If you can go please to tab 8, which is the CV that was produced by Claimant in this case, and you go to the 4th page, you'll see there is a portion highlighted. 4th page. The last page. Here you will see as well that you are mentioning CARICOM's agreements with Venezuela, Colombia, and Cuba. Also, the Dominican Republic is not mentioned in your description of your tasks during this time. Why you haven't included that here as well?
For the same reason it was included previously, which is at one of the agreements that I negotiated, but it wasn't again the most significant. And there, as I look at it, there are many more that I did not include.
Okay. Fair enough. But if you go to the 2nd page, you mention in the CV that you submitted in this case, you mention your career accomplishments, right? Page 2.
Mm-hmm.
And if you go below, I think it's the one, not the last bullet point, but the one just above.
Mm-hmm.
It says, as one of your career accomplishments, led Jamaica's negotiation team in numerous free trade agreements, including CARICOM Dominican Republic, CARICOM Venezuela.
There you go. It's mentioned.
Exactly. So you mentioned the other 3, and you added the one with the Dominican Republic, right? As one of your career accomplishments.
Yes.
Okay. So don't you think that if it was one of your career accomplishments, wouldn't it be mentioned in the prior CV that you submitted to your political party in 2017 before this case started?
No,
and
really.
that is publicly available to everyone in your party and actually online? We found this online. Or you would have mentioned it within your descriptions as parliamentary secretary in the same CV, last page that I just showed you before, that you also have not included that negotiation?
Not really. What is significant is that I did, in this page, remembered it and it was included. The fact is, it still remains the case that there are several other agreements that are equally significant or perhaps more significant that are not included. For example, the agreement I mentioned between the ACP, the Africa, Caribbean, and Pacific Group, with the European Union. That I consider to be a landmark negotiation, but for one reason or the other, perhaps either because of the length of the information, it just wasn't included. And if I, on reflection, if I had to go back and go through it very in detail, I would have mentioned a lot more.
Okay, but if it was one of your career accomplishments, wouldn't it be logical to have included that?
No, I will make the point. There are other career and even agreement that I considered even more significant that is not included.
They are not included in your
Not
prior
included.
and not here.
Not there and not in
Okay,
the prior.
we'll review that. Until 1997, you were parliamentary secretary of the Ministry of Foreign Affairs and, of Jamaica, and at some point in 1997, you became Minister of State within the Ministry of Foreign Affairs, correct?
Correct.
Okay.
As I've said previously, correct.
Okay. And then you said that before that, in the year 2000, you became Minister of Foreign Trade, correct?
Correct.
Okay. Let's go to paragraph
For
9.
the first time.
Yeah. Let's go to paragraph 9 of your second witness declaration.
Paragraph 9.
Okay. 1 second. Okay. Here you say, moreover, as Minister of Foreign Trade, as I then was, I directed trade policy at the national level and had a lead role for Jamaica CARICOM at bilateral ministerial level with the Dominican Republic during the negotiations in question, right?
Correct. That's what's there.
Okay.
Correct.
You also say in paragraph 7 of that witness declaration that you were at the end, of this, the lead minister for CARICOM in these negotiations, correct?
Correct.
Okay. But isn't it true that you only became Minister of Foreign Trade in the year 2000?
Let me explain for the benefit of the tribunal. It is considered there are different positions, certainly in our systems and in the Caribbean and Commonwealth parliamentary system, that a minister of state is considered a minister in the particular ministry and hold a high level and participate at ministerial levels. And so the fact it is the case that I became foreign trade minister, but I was a minister in the Ministry of Foreign Trade previously, as I testified to. So to say, and it was the case that I led the negotiation as Minister of State, and not just this negotiation, but several others.
Okay, but you say here as Minister of Foreign Trade, as I then was. You don't say as Minister of State within the Ministry of Foreign Affairs, as I then was, right?
Yeah, but that's a detail. I mean,
no, it's an important detail.
No, it is not misleading to say. If I reflect on it, if I reflected on it, I may have made the change, but it's a slight change because it's still what it does reflect is that I had ministerial level responsibility in the Ministry of Foreign Affairs and Foreign Trade.
So you want to correct your witness declaration?
I mean, out in our abundance of caution, I'd say Minister of State in Ministry of Foreign Trade, but the responsibility remains the same.
Just let's go back to your to tab 7, where you describe which were your main tasks during each of your positions.
Tab when?
Tab 7, page 4, please.
Page what?
Page 4, again, the one we just saw before, of tab 7. Okay. So there you describe your main role in each of the positions that you held. So what do you say was your main role as Minister of State that I think you were a Minister of State within the Ministry of Foreign Affairs within the year 1997 and the year 2000. Can you please read to us what was as you describe your main role in this position?
Certainly as it relates to the topic at hand, I led those, I was responsible for settling trade policy.
Okay, you say here, I'll read to you, that your main role was chaired the Committee on Jamaica's Ocean and Coastal Zone Management Policy. So you did policy, I agree with you, but chairing the Committee on Jamaica's Ocean and Coastal Zone Management, right?
One of the responsibilities.
That was one.
One of the responsibilities.
But before your
There are others I've not included. Air
Okay.
policy.
If you are a minister of state, would you be considered a cabinet minister?
Well, not in the, you're invited to cabinet on the particular matter for which you have responsibility.
But you have a limited responsibility as a minister of state, right?
Correct.
Because you're not a cabinet minister.
Correct.
Okay. Let's see. So you also,
let me just clarify.
sorry,
I'm not a,
I
I'm not a portfolio.
haven't made any. I mean, I haven't posed any further questions. You have time to clarify during redirect examination.
Mr. Chairman, I think he is clarifying the answer he just gave. He's not
Yeah.
asking
I
to
mean,
say
he
anything
finished his
else.
question.
Please, you can.
Yeah, I'm simply making the point for out of abundance of caution, since we're going into a level of details didn't expect. The fact is, I have responsibility at cabinet level for those portfolio areas that have been assigned.
Okay, so you had cabinet.
Cabinet level responsibility
Yeah,
for those areas.
because you were chairing the Committee on Jamaica's Ocean and Coastal Zone Management Policy. So you have cabinet. That
For
was
that
your.
and others, and the trade policy as well.
Okay, but that was not mentioned here, right?
Yeah, but I'm saying this is for internal consumption, not public consumption.
Well, we
There's a
found
lot that is not mentioned here.
Okay, we found it in the internet, so it's always obviously publicly available, right?
Well, that was not the intended purpose.
Okay, fair enough. What country signed the free trade agreement with between the Dominican Republic and CARICOM on behalf of CARICOM?
The heads of, as I recall it, the heads of government took a decision that the chairman at that time would sign on behalf of CARICOM.
Okay, and who signed then? Do you know?
My recollection, it was Kenny Anthony, who was then the chairman of CARICOM.
He was from what country?
St. Lucia.
Okay. You discuss in your witness statement, second with declaration, paragraph 6, you say that CARICOM is a regional body in which each state member retains sovereignty and having to each ratify a treaty before it comes into effect.
Correct.
You also say at paragraph 6 that CARICOM is not a supranational body like the European Union, which is given the power to negotiate trade agreements for and on behalf of the entire membership of the Union, and that CARICOM does not exercise an executive function, correct?
Correct.
According to your view then, when did the free trade agreement between the Dominican Republic and CARICOM enter into effect?
Well, first of all, it was provisionally applied.
Okay.
Provisionally applied, and under the Vienna Convention that gives it effect, in a sense, and unless you enter a reservation as a provisional application, then it's assumed in good faith that you have to, that the treaty binds you. Because the ratification processes are different for different countries,
yes,
you have a period of time in which to ratify those agreements. But it was provisionally applied.
You know when it was provisionally applied?
I don't want to guess, but I would think that Jamaica, if I remember, signed somewhere in 2000 or 2001. Well, when was it provisionally applied?
Yep.
I believe almost immediately after it was negotiated.
Do you know, as you're part of the Jamaican Parliament, do you know when the Jamaican Parliament ratified the free trade agreement?
The Parliament did so recently, most recently. I think it was 2014.
2014,
Yeah.
correct.
Yeah.
Yes. Are you aware? Do you know if every member state of CARICOM has ratified the free trade agreement to date?
I've not checked.
No.
I don't know, but again, my position remains. As long as it is being provisionally applied and you have not entered a reservation, it would apply to you.
Okay. So if I understand you correctly, for example, your view is that it was provisionally applied,
Correct.
but then the free trade agreement enters into effect. I mean, if I understand correctly what you say in your witness state declaration, enters into effect with respect to each CARICOM member once it ratifies the free trade agreement, correct?
Formally. That's just a formality.
Formally.
Correct.
Okay. And that is because CARICOM does not exercise an executive function and is not a supranational body which has the power to negotiate free trade agreements for and on behalf of the entire membership like the European Union, right?
Correct.
Would you agree then that the powers of CARICOM as an organization are rather limited?
No, not at all.
Okay. Sorry. That is because CARICOM does not exercise an executive function and is not a supranational body which has the power to negotiate trade agreements for and on behalf of the entire membership, like the European Union, correct?
Correct.
Correct. Okay. Then I ask, would you agree then that the powers of CARICOM as an organization are rather limited?
Not at all. Let me explain. Each CARICOM member state retains its sovereignty. It agrees, as does any state as a sovereign. It agrees when and under what circumstance it will give up aspects of that sovereignty through agreements. In this instance, CARICOM, all member states retain full sovereignty until and unless they agree to part with any aspects or any part of that sovereignty. So I think to the contrary, CARICOM member states retain full sovereignty. In the European Union, they have given up aspects of that by agreement, which again is an exercise of sovereignty.
Okay, but then, as you said before, each one has to ratify the treaty before it comes into effect, right?
No.
That's what you said in paragraph 6, right?
That's not, sorry, Counsel, it's not what he said.
Yeah, I said unless it's provisionally applied and they have not entered a reservation. It is understood that they would formally ratify that agreement. The timetable cannot be given by the nature of the different ratification procedures.
You said in paragraph 6, I'll read again.
Paragraph 6, one?
Yeah, 6 of your second witness declaration, sorry.
Correct.
Because you said you didn't say that. The state's second argument attacking my credibility misapprehends.
Please. I need to follow you. You were saying?
I haven't made any questions yet. Just let me read first.
I'm trying to follow you. Go ahead.
Okay. The state's second argument attacking my credibility misapprehends the nature, organization, and function of CARICOM as a regional body, which is made up of individual member states, with each member state retaining its sovereignty and having to each ratify a treaty before it comes into effect, right?
Could have said full effect.
Okay.
Could have said full effect, but it becomes operational.
Provisionally.
Provisionally.
Okay.
Correct.
But each one has to ratify individually.
Ultimately.
Correct?
Ultimately, yes.
Correct. Perfect. Have you participated specifically in the negotiation of Annex 3 of the investment annex of the free trade agreement between the Dominican Republic and CARICOM?
Well, it depends on what you mean participated, because again, I made a point earlier that I participated at another level. There are other levels of participation. My participation was at ministerial level.
Okay.
And as such, Annex 3 would come before the ministers for direction and for agreement.
Do you know how much time was devoted to the negotiation and discussion of this investment annex during the negotiations of the free trade agreement?
Can't recall.
Okay. Were you aware that CARICOM initially proposed in early 1997 that the free trade agreement should not contain an investment chapter or annex, and instead that each member state of CARICOM should sign independently bilateral investment treaties with the Republic?
I'm not particularly aware, but it doesn't surprise me. I'm not particularly aware that was the discussion, and that would depend on what level that the discussion would occur. But it never occurred at my level.
Okay, you can go to tab 9, please. It's not a great copy, but if you look at the second page, there is a highlighted portion. The next, you could, yeah. This is the proposal, CARICOM's proposal. If you just go to the next page, please, you will see that there is a highlighted portion.
What is it? Oh.
Yeah, and that portion, that was the text proposed by CARICOM in early 1997. I'm not sure at what level, but this was the text proposed by CARICOM. And you can read it yourself, Article 10. please read it and let me know if you agree with me.
Agree with you on what?
If that CARICOM was proposing that the free trade agreement should not contain an investment annex or chapter, and instead that each member state should sign independently bilateral investment treaties with the Dominican Republic.
No, I can't agree with you. I mean, what this says is that there is another approach. At some point, that approach shifted. But this does not say you should not sign, this does not say you should not consider or sign investment bilateral an investment.
Okay, what does it say?
Reciprocal investment agreement.
Okay, what does it say to you? Sorry, can you read it first and explain to me what do you understand by this?
All right. Well, what this suggests to me is that at different points in the negotiation, there are different approaches being considered. One approach is what is contained here. Again, not inconsistent because individual member states may want to negotiate bilateral investment treaty or BITs, which is quite normal. So I think at some point a decision was made that should not be the case, but that there should be an agreement within the four walls of this agreement.
Okay. Have you seen this document before?
No, can't recall.
Never?
So.
Okay.
No.
So you don't know who proposed this text, right?
Not at all.
But you haven't seen it?
No.
Okay.
I'm assuming someone from CARICOM proposed it. I see it said Mark CARICOM, maybe, I don't know, I'm assuming they did, but
okay.
If they did, it's not at my level.
It was not at your level. It was at another level.
I've never seen it.
Okay, that's fine. The first draft of the Annex on Investment was made by the Republic in September 1997, was transmitted to CARICOM during the second round of negotiations in November 1997, correct?
I don't recall that.
You don't recall?
No, I don't recall this.
Do you know if you participated in that second round?
At what level?
There were meetings, the first round, there were meetings in Jamaica that we saw your name on it. Then there was a second round of negotiations where there were meetings in the Dominican Republic in November.
Who is they that was meeting?
There were meetings, CARICOM and the delegates of the different countries of CARICOM and the Dominican Republic met in November 1997 in the Dominican Republic. I'm just asking if you...
No. Chairman, for clarity, again, I've said CARICOM has had meeting at several different levels. Unless you are saying to me that was specifically a ministerial level meeting, I would not be, I can't attest to that I was there.
Mr. Hildon, but do you remember that you were at that meeting, that date, the council?
No, I don't have any specific recollection.
Okay.
So, so then you did not attend the meetings where the Republic made the proposal that the free trade agreement should include an investment annex, right?
I can't say. I don't recall what level, what meeting that was first proposed. I know at some point it came to my attention that was on the table. Okay. In fact, to be fair, I'm not sure, and I can't say I'm certain that was first made by the DR. It may have been done by CARICOM. I'm not sure, but at some point that came on the table for discussion.
Okay. If you go, let's go first. Okay, so you haven't, at that time, you haven't seen, at least you don't recall seeing what was the proposal of the Dominican Republic in November 1997?
No, not specifically.
Okay. If you go to tab 10, this was the proposal of the Dominican Republic in that meeting in November 1997.
November,
in the
did you say November?
November, yeah. September they drafted it and they transmitted it to CARICOM in November. And then it says September 17 because that was when the draft was made. You see here we have a translation of Article 11. You can read it for yourself. That was the text that the Dominican Republic proposed to CARICOM in the second round of negotiations.
Okay.
Have you seen this document before?
Don't recall.
Are you aware that the Republic made a proposal that did not include an investor-state dispute settlement provision?
No, not specifically.
Okay. The first draft of the current Article 13 of Annex 3, which at that time was called Article 11 of the draft investment chapter, was proposed by CARICOM during the third round of negotiations.
Please, let me... No,
Okay.
I see Article 11. No, I don't know if it's Article 11 of Annex 3. There are different articles. There are different article levels. There's Article 11 of the main agreement. There's Article 11.
Please.
I don't know
which of... You can turn to the... After the blue sheet, you
in
can...
fact,
this is a
joint
translation,
council. A joint council.
Yep.
The reference here to a joint council is a reference to a joint council that is provided for in the main treaty.
If you please turn this blue sheet, and you will see in Spanish, I'll read it to you. I'm not sure if you're able to understand. Anexo 7, Acuerdo.
Annex 7, agreement between CARICOM and the Dominican Republic for the promotion and reciprocal protection of investments.
It was called Annex 7, agreement between CARICOM and the Dominican Republic for the promotion and reciprocal protection of investments. And if you turn that page and you see Title 5, Solución de Controversias, that's dispute resolution, and that's what we translated before. So as you can see, this was the dispute settlement provision included in the annex that at that point was called Annex 7 of the negotiation regarding investments, correct?
I can't say correct. I don't recall specifically.
Okay. The first draft of current Article 13 of Annex 3, which at that point was as I was telling you, was called Article 11 of the draft investment agreement, was proposed by CARICOM during the third round of negotiations in March 1998, correct?
I'm assuming a particular date. You're suggesting
You don't remember?
I don't remember specifically what time period. Yeah.
Okay. Please turn to tab 11. After the first cover page, you'll see there is a list of delegates who participated in the third negotiating meeting. And here from Jamaica, you see there are 4 names. Your name does not appear there, right?
It shouldn't.
Why?
It's not my level.
Okay, but it was not your level?
No.
Okay. So you did not participate in this meeting at this level where the Dominican Republic, where CARICOM proposed or gave its comments to the Dominican Republic on the investment annex?
No.
Okay. After this meeting, have you participated in any other of the negotiating rounds?
I'm sure I did.
You did?
I'm sure I did.
But have you seen this document before? Can you please turn the blue sheet and see the comments that CARICOM gave to the Dominican Republic on this free trade agreement? Have you seen this document before?
Mr. Chairman, I'm sorry, I'm not sure what tab we're on.
Yeah, sorry, that's tab 11. After the list of delegates, there is a blue sheet, and we have a document titled Comments, CARICOM's Comments on Agreement on Reciprocal Promotion and Protection of Investments. Have you seen this document before?
This is becoming familiar. This version, I recall seeing. I can't recall the timeline, but I recall that this particular formulation I'm familiar with.
Okay, but so you told us before you did not attend the third round of meetings at Trinidad and Tobago, where this was transmitted, where these comments were given to the Dominican Republic, right?
I'm consistent. Yes, correct. I did say that.
Okay, so you were not at that meeting at least.
Which meeting?
The one that we just read before the list of delegates, the third round of negotiating.
Probably not, but I've said I recall seeing this formulation.
Perfect. Okay. In which context did you recall seeing this formulation?
It must have been because I'm not participant in other contexts. It must have been at an internal ministerial level discussion where this formulation would have had to come to the ministerial level for sign off at this level, because it's clear, given the formulation, which looks somewhat similar to the final version, that we're now getting closer to a settled position on the dispute settlement.
Okay, and this ministerial level discussion was in Jamaica?
I can't recall.
But it was not the meeting that took place with all the delegates in the Trinidad and Tobago?
I can't recall because sometimes there is a technical level meeting before the ministerial level. And sometimes the ministerial level meeting takes place at the same venue. Sometimes it doesn't. So I'm saying specifically, unless there was a ministerial, if you tell me there was a ministerial level, it is quite probable that I was there.
Okay. At what level then these negotiations take place? At a ministerial level, at a technical level? Which meeting levels would then be the ones in which these drafts or comments are exchanged?
Negotiation takes place at all levels.
Yeah, but there is a certain formal meeting as the one we see here, where formally the CARICOM presents its comments to the Dominican Republic. At what level, and this meeting in particular, that's what's happening. At what level does these comments are handed to the other party?
It could be at the ambassador level. It could have been at an expert level. And it's possible that it could have been at, again, I've said this formulation is familiar. I have a recognition of this formulation. Whether it took place at the ministerial level or at another level, I can't recall specifically.
Okay. If you go back to the first part of tab 11, where we see the list of delegates,
yes,
we see 4 names for Jamaica there. The first name that appears there is Strafford Neal, and his position is Permanent Secretary, Ministry of Foreign Affairs. That was your former position, right?
No.
Before you became Ministry of State?
Not at all.
No?
It was Parliamentary Secretary.
Parliamentary Secretary, okay. And then you see other 3 names. So how would you qualify this meeting given the people who participated? This is a ministerial level?
No, senior officials.
Senior official meeting.
Correct.
Okay.
Council, you have 5 minutes left, okay?
Okay. Okay, we have no further questions. Thank you very much.
Thank you.
Thank you. Please, Claimant, you have I'm sorry. Yes, go ahead. I'm sorry.
Hello, sir. I'd just like to follow up with a few questions, if I may.
Sure.
In your second declaration, and around paragraph 10 and 11.
Correct.
And at the top of paragraph 11, you talk about, you readily recall the broad policy decisions. You see that?
Correct.
And you say such as those relating to the dispute resolution clause. Can you explain what was it about the dispute resolution clause policy that was memorable?
Well, as I mentioned earlier in my discussion, in my response, at an early stage, it had become clear that Law 173 was posing a difficulty. In particular, we became aware that there was an interpretation of Law 173 that it could not be submitted or subject to international arbitration. That was very concerning to us. And so at that juncture, it became very clear in our minds that we had to have a very tight dispute settlement mechanism, and that in fact what was preferred was to have international arbitration, but that had to be within the gift, had to be provided for the investor as a choice, a forum, and that was a policy direction that we had to have consent, and that we couldn't leave that up in the air, but that there needed to be prior or ex ante consent on the arrangement at that point, and that we were very clear about that.
Now, I'm not an expert on Law 173, but is Law 173 something that is enforced between states, or does it also have an impact on investors?
It would impact investment in that, as we've said, if you make an investment in the DR, as we understood it, and it was explained to us, you would have had to use an agency in the DR. And the problem we had was that getting into the agreement was one thing, getting out of it was an entirely different thing. It was very costly. It would have proved very costly to get out of it. And this agreement was part of the Constitution, and we had a problem with that.
And this is the Constitution of the Dominican Republic?
Dominican Republic.
And so was it a change in negotiations, or was it the accomplishment of something that was so memorable to you on this topic?
Well, the issue on trying to get a resolution to the problem, and we were satisfied at the end because we had gotten the consent. We believe we had gotten the consent of the DR for international arbitration on any issues arising from the application or interpretation of the treaty.
And you're a lawyer. Were you involved in specific wording negotiations, or were you at a policy level?
Large the policy, but at my level, we would be understanding what the agreement says in particular. So I'd be paying attention to the wording. I can't recall that I provided any wording. That may have been done at the technical level, but certainly by the time it came to us, we were satisfied that the objectives were met, which is to give prior ex ante consent to the arrangement.
Thank you.
Sure.
Good afternoon, Ambassador.
Good afternoon.
I have some questions concerning Annex 3.
Sure.
You have the text. You have the text of Annex 3 in tab 3. My first
tab 3 of this document.
Tab 3 of this folder. Yes.
Okay.
This is the text of the CARICOM Dominican Republic Agreement.
No, please. This is the text of
the CARICOM Dominican Republic Agreement.
Okay.
You have it in Spanish and in English.
Yes.
My first question concerns Article 3 of Annex 3. It is at page 82.
Page 82, okay. Article 3 of?
Annex 3.
Okay,
Do you have the text in front of you?
I do.
It reads, each party shall admit and treat investments in a manner no less favorable than the treatment granted in similar situations to
No,
investment.
please. Let's just 2. Let's just say Article 2, paragraph 2.
I'm reading Article 3.
Reading Article 3.
At the bottom of page 82.
Okay.
Yes? Are you there?
Yes.
I read it again.
Yes, please.
Each party shall admit and treat investments in a manner no less favorable than the treatment granted in similar situations to investments of its investors, except for investments in areas to be identified in the appendix to this annex.
Okay.
Do you know which areas have the negotiators in mind?
Can't now recall.
Yeah, okay. Do you know that there is no appendix, apparently, about this appendix that is mentioned, apparently doesn't exist?
Yeah, but that's why I don't recall.
Yes. So, do you remember what happened?
No, not at all.
You don't remember.
No.
You also don't know why this reference to an appendix that doesn't exist was kept in the treaty.
No, can't now recall.
Okay, thank you. Now we move to Article 13, which was mentioned many times, and you mentioned in your statements. And I would like you have it just for recollection, page 87.
Sure.
And then in the following page, you also have Article 14. So Article 13 is disputes between investor and a contracting party, and 14 is disputes between the parties.
Correct.
In your first statement, you mentioned that the investor has the possibility to submit a dispute to arbitration.
Correct.
Have a look at Article 14 and paragraph 2. If a dispute between the parties cannot thus be settled, it shall, upon the request of either party, be submitted to an arbitral tribunal. Here there is a reference to the fact that the submission to an arbitral tribunal can be made by the request of either party. There is no similar wording in Article 13.
And there shouldn't be.
There shouldn't be.
There should not be.
Okay, could you please explain me?
Because Article 13 addresses a dispute between an investor and the contracting party, and the whole purpose of Annex 3 was to give protection to the investor, to the investment by way of the investor. And Article 14 deals with dispute between the parties, and here I'm assuming the contracting parties.
Yes.
So there are two levels, different levels. These are the two major parties, sovereigns, and the whole idea is to protect investors. So that in 13, you do want to give the investor the option of choosing its investment, its forum. In this one, the two sovereigns can decide. So I see no lack of coherence or inconsistency in 13 and 14.
I didn't mention any kind of coherency or not. Just I'm asking you.
It's fine with me.
What is?
It's fine. Quite fine.
In your view, this is the explanation. It was not needed in Article 13 to explicitly mention that it can be at the request of the
But that was not the intent of Article 13. Article 13 was to secure ex-ante agreement, a prior agreement with the contracting parties. The consent of we needed to have the consent of contracting parties in 13. In 14, the sovereigns can decide.
Each of them?
Each of them, in 14.
Did you participate in any manner, at any level, in the wording or in the authorization to submit the proposal of CARICOM to what became Article 13?
I would naturally, because it would have to come to the ministerial level. It may have been proposed at technical. Once a dispute arises and you're trying to settle that dispute, it would have to come to the ministerial level for direction.
Can you explain specifically how you participated? In which manner? Drafting, reading and authorizing? Or?
Well, as I have said, at the different levels, particularly at the technical level, that's where a lot of the detail work would take place, the drafting and detail work. If there are no issues, if there are agreement and they can be settled at that level, then the issue doesn't arise at the other level, which quite likely, and in my experience, would be at the ambassadorial level or senior official levels. If the disagreement persists, then it will come to the ministerial level for direction.
Okay. You participated in the negotiations of CARICOM with Cuba for a similar agreement.
I recall being involved in the negotiations, yes.
Did you meet Cuban diplomats for that negotiations?
Is the question, were Cuban diplomats at the meeting? I'm sure there were.
Yes.
Yeah, I'm sure there were. Yes, I'm sure I did.
And do you know whether Cuban diplomats were favorable to international arbitration in disputes between foreign investors and state?
Can't recall specifically, and I can't recall. What I recall, well, the fact that I don't recall means that there was not a major dispute between Cuba and CARICOM on that issue. If there were, I would have recalled, I think.
Okay, thank you.
A very last question. Are you satisfied with the wording of Article 13? So do you think that really with this wording, the policies you have fixed were achieved?
Correct, I am.
Okay, thank you very much. Please, Mr. Chesky.
Mr. Chairman, if we could just have 5 minutes, and we can count it against our half an hour. So we'll be no more than we already allocated.
5 minutes,
Yes.
keeping here?
Yes.
Okay, 5 minutes.